So, colleagues, we begin the hearing on the Facebook Cambridge Analytica case. This is the first of a series of hearings on the Facebook Cambridge Analytica case. And I welcome all of you on behalf of the Libe Committee, and we are associated today with the ITRE Committee, AFCO and Jury Committees. For the AFCO Committee, the Chair will be Mrs Spinelli, and for the Jury Committee, Mrs Ferrara, and for ITRE, Mr Kelly. Also present are the First Vice Chair of the IMCO and CULT Committees. For IMCO, Mrs Karatza-Bilt will join us, and for the CULT Committee, Ms Verheyen will represent the Chair. So we've tried to widen this as much as possible, and I hope colleagues will find that as open and as democratic as possible. Today's hearing is the first part of a series of hearings, as I mentioned, following a decision of the Conference of Presidents on the 12th of April, and following the meeting with Mr Zuckerberg at the level of Conference of Presidents, which many of you may have already seen. The purpose of today's hearing and subsequent hearings is a bit different, though. It's to hold an in-depth committee hearing with the key interlocutors in the Cambridge Analytica and Facebook scandal. The aim of these hearings is to dig deeper, learn key lessons, and set out the way forward using the EU tools at our disposal. So today's first hearing will help us map the case and to understand in detail what has happened, why it happened, and how things could evolve to this point. The second hearing will take place on the 25th of June, and a third hearing on the 2nd of July. And some of those hearings will, of course, involve Facebook. Today's hearing does not involve Facebook. Colleagues, let's start today's hearing right away, and we have an interesting panel. But before we start, I just want to remind you of the rules. We're going to follow a quick and easy format, one question per member set out, and then one answer from the specified colleague who you want the answer from. Prior to the meeting, political groups agreed to allocate the 27 slots for questions. Political groups were invited to share the names of the members that would speak on behalf of their political groups, and based on those 27 names, the speakers list was established. After the presentations by our panellists, I'm going to give first the floor to the chairs of the committees concerned, after which I will follow the established speakers list. But again, just a reminder that you will ask a single question. When you ask your question for a maximum of 1 minute, so you ask your question for a maximum of 1 minute, you indicate who that question is directed to. So you don't just ask a general question, because there is only one answer coming back. So please do the courtesy of indicating who the question is to. And then each of the panellists will have 2 minutes to respond. I will cut off anyone that goes beyond the 1 minute. If any member is not on the list, the following speaker is going to be given the floor. Finally, I'm going to introduce the speakers to you, and each of them is going to make a short introduction. We have Mr Sandy Parakalis, Chief Strategy Officer at the Centre for Humane Technology and former Operations Manager at Facebook. Ms Carole Cadwalladr, Senior Journalist at The Guardian, who investigated and broke the story on Facebook and Cambridge Analytica. Ms Elizabeth Denham, Information Commissioner at the ICO United Kingdom, investigating the Facebook data scandal. She's accompanied by Mr James Dipple-Johnson, the Deputy Commissioner. Professor David Caroll, Associate Professor at the Parsons School of Design in New York, who filed a legal challenge in the United Kingdom asking the court to force Cambridge Analytica to disclose how it came up with the psychographic targeting profile on him. And finally, Christopher Wylie, the whistleblower and former Director of Research at Cambridge Analytica. And I'd really like to welcome all of them and thank them for being here today and responding so quickly to the European Parliament's invitation. So we now move to... We're going to have the introductions first.
No, we can start with the first one.
Okay, so we now move to the introductions from our speakers, colleagues, and we begin with Sandy Parkalis, the Chief Strategy Officer at the Centre for Humane Technology and former Operations Manager at Facebook. And you have the floor. Thank you.
Thank you so much for the opportunity to come and speak to you today. My name is Sandy Parkalis. I'm the Chief Strategy Officer of the Centre for Humane Technology, which is a new not-for-profit organization focused on realigning technology's interests with those of humanity. And as mentioned, I was an operations manager at Facebook back in 2011 and 2012. And one of my main responsibilities at that time was data protection on Facebook platform. So I wanted to come here and speak to you all about what happened from the Facebook side with Cambridge Analytica and talk a little bit about things that can be done to improve the situation moving forward. So before we get to some specific examples of how Facebook was involved in the Cambridge Analytica scandal, I wanted to very quickly walk you through how Facebook platform works. So the thing to understand about Facebook platform is that it is a service that the company offers that allows external developers, external apps, to build applications that access user data from Facebook users. And this works both on the desktop web, as you can see on the left, and on mobile devices, as you can see on the right. One of the key things to understand as part of this investigation, I think, is how do apps actually get data from Facebook, as that is the key thing at issue here. So whenever a Facebook user wanted to use an application, a Facebook application, they would agree on a consent screen that looked something like this. This is from several years ago, but there are new versions of this screen. When the user taps allow, the application, in this case Amazon, receives data as specified in the consent screen that the user has agreed to. So here's how the data flow works. First, the user provides information to Facebook, whether that's their name, other information about themselves. Then they consent to this application to access specific data, and then Facebook passes that data to the application. And here's where we get into the problem with Cambridge Analytica, which is that once the application has this data, there is in fact no way for Facebook to know what the application developer is doing with the data. And so that means that if the developer is a bad actor, they could pass data to an unauthorized fourth party. In this particular case, the developer was Alexander Kogan, and the fourth party was Cambridge Analytica. Now, another key thing to understand is how developers were able to access data without explicit consent of users. So the key thing to understand is that until 2014, or actually until 2015 in some cases, Facebook apps were able to access not just data about the users of those applications, but also data from the friends of the users. And on average, Facebook users have 200 or 300 friends. So there is a massive, massive increase in the amount of data that applications can receive when they are using what are called friend permissions. And there is a new breaking story that's out literally this morning in the New York Times that you are welcome to ask me about in the Q&A if you want to hear more about, but there was an update to whether this continues or not. All right, so let's talk about the data itself. So there is quite a bit of data that developers could get from Facebook. Here's a list of some of the data that was available before the change in 2014. So you can see that developers could access things like user actions, they could access posts, they could access more sensitive things like relationship details, religion and politics. They could access all of that for friends as well, before friend permissions were deprecated. And there were extended permissions that gave developers more access to data in some cases. For example, for users, extended permissions could enable a developer to read private messages as well. So let's talk about what went wrong with Cambridge Analytica and Facebook. So first of all, Facebook had no ability to monitor or control data usage after it passed data to app developers. Second, they allowed apps to access data from friends without explicit consent. Third, they did little or no vetting of developers. Anyone could make a Facebook app. And fourth, in the case of Cambridge Analytica, they relied on the developer's word that they deleted the data. They didn't conduct an audit or file a lawsuit at the time that they uncovered this abuse. And finally, Facebook did not ban Cambridge Analytica from advertising on Facebook after they took their initial enforcement action in late 2015. And so Cambridge Analytica was able to continue advertising for another 2.5 years until March of 2018. So there's a lot there to this particular issue. But one thing I wanted to call out is this problem is much, much larger than Facebook or Cambridge Analytica. This horrible map is an accounting of the advertising technology industry, and every tiny little logo is a company that is in some way involved in the business of, at the end of the day, converting users' data into money. And so you can imagine that trying to regulate such a complicated industry is going to be extraordinarily challenging. So the good news is GDPR is a great first step towards defining rights for users. But as I mentioned, this is a very, very, very complicated problem. And so I wanted to outline 4 things that I will quickly highlight at a high level that I think that this body can think about as you look to do additional regulation. The first is that we want to ensure comprehension, not just consent. So this is the terms of service consent screen that Facebook says complies with GDPR. And what I would call your attention to is the fact that the links to actually read the terms and the link to see your options are tiny. And the button to accept and immediately move on to just use Facebook without reading anything is very large. So I think it is fair to say that this page is designed to get the user to accept. And so we need a framework to ensure that users are actually comprehending what they are agreeing to, not simply consenting because that's what the user experience makes them want to do. The second point I wanted to make, we have to find ways to align corporate and user incentives. And a really good metaphor here is seatbelts. So in the United States, the auto industry was actually perhaps less of a driver of the implementation of seatbelts than was the auto insurance industry. And the key thing to understand is the insurance industry had to pay out claims whenever a rider or driver in a car was injured. So they cared a lot economically about the safety of those people. We can do something similar with data protection. And in fact, if we create a robust cyber insurance framework, we could leverage the insurance industry in a similar way. And we can ensure that they are responsible for educating both users and companies about best practices. And we can spread the risk of large penalties out across many companies, which will enable us to ensure that when there is effectively an oil spill that one company couldn't pay to clean up, that payment can be spread out across the industry. The third thing I wanted to mention is about programmatic access to data for users. So similar to insurance, we need to create companies that have interests that are aligned with users and protecting users' data. That is incredibly important to succeed here. Rules alone will not work. So I wanted to show you a quick personal example, which is my Google search history from 8 years ago, which Google still has. And I know this because I went to their My Activity tool, and I was surprised and a bit annoyed that they still have this data. But the reality is very few people actually go to the trouble of managing all the data that's been collected about them because it is so hard to do across all of the services that they use. So if we enforce a requirement for programmatic access to data and data protection functions, we can create a new generation of companies that are actually trying to help users manage their data, that can build new tools to do that, whether it's deleting data that people don't want or helping them aggregate and move their data to different companies if they so choose to do so. And the fourth and final point I wanted to make here is, as we think about new regulations, it's very important that we think about protecting small companies. Small companies are the ones that drive innovation in the technology industry, and it's very, very important that we think hard about how we can help them comply with new rules and how these new rules will impact them. We do not want to further empower entrenched monopolies through regulation. And finally, I just wanted to say, the world looks to this body. You are the ones who are driving innovation in regulation on data protection. And I can assure you that polling data shows that a large majority of Americans want something in the US like GDPR, and most of the tech company employees that I talk to do as well. So thank you, and I look forward to your continued innovation on regulation on this matter. Thanks.
Thank you very much for your kind words about GDPR. The mother of GDPR is here. I don't know if the father is, wherever he is. Is he here yet? No. No, that's right. Okay, and we didn't ask you to say those kind words, just for information. I should have mentioned that all the witnesses, colleagues on the podium, were asked to make a presentation of up to 10 minutes. So next, we're delighted to hear from Carole Cadwalladr, the senior journalist at The Guardian, who of course investigated the Facebook Cambridge Analytica story and continues to do so. Carole, you have the floor.
Thank you very much for inviting me here. And I'm very pleased that you're holding this set of hearings, which I just think couldn't be more important and more urgent and desperately require more scrutiny. There is a lot of questions, and that certainly as journalists we haven't been able to find answers to. My background is that I have been investigating these issues now for more than 18 months. And there's all sorts of things I could talk to you about, but what I thought I would focus on is particularly the European referendum and the questions around that. So there are multiple investigations which are currently going on in the UK into the conduct of the Leave campaigns. There is an investigation by the Information Commissioner, who is here. There's an investigation by the Electoral Commission. There's multiple investigations by the Electoral Commission. There is now an investigation by the police. We now have the inquiry, the parliamentary inquiry, which is being led by Damien Collins. And they're looking into all sorts of potential crimes, such as illegal overspending, illegal sharing of data, potential deletion of evidence, illegal coordination between campaigns. I just want to the background to our electoral laws in the UK is that we control the money that is spent during the campaign period. And that is the foundation, that's the bedrock of our democratic constitution. And that legislation has developed over 100 years. And what has happened in the last few years is that digital campaigning has fundamentally changed the way those laws. We're in a situation where actually those laws don't work. And that is the view of the sort of leading academics and legal experts. That now everything is running through the black boxes of the tech companies, and we have no idea what is going on inside those black boxes. So what this means critically is that we have no idea how much money was spent during the referendum. We don't know who spent it. We don't know where that money came from. We don't know what advertisements people saw. We don't know how those people were targeted with those advertisements. We don't know what data that was based upon. So that information does exist. It exists inside Facebook servers, inside Google servers, but we've got no access to them. We've got no visibility. So we're in this situation now where we have these foreign companies which have played an absolutely pivotal role in an absolutely pivotal election, and we have no means of obtaining that information. I thought it would be instructive to tell you what it's like as a journalist trying to seek answers to these questions, and it is almost impossible. So The Guardian first reported on Cambridge Analytica and the harvesting of Facebook data back in December 2015. That was a journalist called Harry Davis. And a lot of what we know now, we knew then. And Harry went to Facebook and asked it all sorts of questions, and he did not get answers. Subsequently, other journalists came. They also wrote about this. So Hannes Grassedger in Switzerland and Matthias Schwartz for The Intercept, myself for The Observer. And we did not get answers. And that is what these tech platforms do and have gotten away with. They just deny, they evade, they evade. In our case, they actually kind of threatened and intimidated us before publication. And then when they do acknowledge that there is an issue, we get this incomplete disclosure. So Sandy mentioned today that there was a news story yesterday in the New York Times where we're learning that the answers that Mark Zuckerberg gave to Congress were incomplete. I think we can, if they weren't actually misleading, I think we can say that they were incomplete. So which is why it's so important what you're doing here, because I think you're probably the one institution which has got the authority to be able to stand up to the tech giants. And I think you are the one body that they are actually scared of. And so I really hope that you will hold them to account in a way which we did not see when Mark Zuckerberg came here a couple of weeks ago. I feel that he was allowed to appear to be cooperating whilst not cooperating, which is a kind of classic modus operandi we see. Just a little bit of background how I came into the story, which was in December 2016. That was when I first heard about Cambridge Analytica from an academic in America called Jonathan Albright. And I wrote about them in an article, and I said that they'd worked for the Trump campaign and for the Leave campaign. And I started getting letters from them saying, we never worked for the Leave campaign. And this was baffling, because all over the internet there were articles about how they worked for the Leave campaign. There were statements from the CEO, Alexander Nix, about how they worked for the Leave campaign. On Leave.eu's website, it said, we hired Cambridge Analytica. So at that point, I went and I met Andy Wigmore, who works with Aaron Banks, a businessman, who is the main bankroller of Brexit. He worked to support Nigel Farage's Leave.eu campaign. And Nigel Farage is a really central figure in all of this. And I really hope that you will use this opportunity of these committees to ask him some questions which we have not been able to get answers to. So Nigel Farage was introduced to, it was Nigel Farage, because of Nigel Farage that Cambridge Analytica was introduced to the Leave campaign, because of his friendship with Steve Bannon and with Robert Mercer. So Steve Bannon and Robert Mercer play a very pivotal role in this. They, as well as lending their support to the Leave campaign, they also brought Breitbart to the UK, which also explicitly supported this, supported Nigel Farage's mission to take Britain out of the EU. Andy Wigmore told me, and this is on tape and recorded, and this was before the denials began, that Cambridge Analytica helped them for free. It didn't need to pay them because he said they had the same aims and intentions as they had in the US. There was a friendship between Bannon and Mercer and Farage. And he said they helped them understand what to do with Facebook data. They taught them how to use other sources of data. They taught them how to use fear and emotion to guide people's responses. Very quickly, I'm just going to just go into what happened next, which was following that, that donation turned out to be potentially illegal. We have to declare donations in the UK as a service. And so after that, 2 investigations kicked off, one of which is Elizabeth Denham is going to report on. But shortly afterwards, a reader wrote to me from Canada and pointed out that Cambridge Analytica had a branch office in Canada, SCL Canada it was called, and he pointed out the director of that branch office was also the director of another company called Aggregate IQ. And Aggregate IQ worked with another Leave campaign in Britain, the Vote Leave, the official campaign. And not just that, it also worked with 3 other campaigns, with the DUP, with Veterans for Britain and Believe. And we have very strict laws against the coordination between campaigns. So it was very obvious that something very strange was going on here. This was a covert, hidden link. And as soon as I asked Cambridge Analytica about it, they deleted those details off the website. It was at that point that I then realised there was something. It was the fact that it was hidden and it was covert. That was the most troubling thing about it. And that was when I went to track down ex-employees, and I found Christopher Wylie, who's can tell you more in much more detail about what he knows. Just to wrap up very quickly, Mark Zuckerberg came here and he told you, we made mistakes, we've learnt from our lessons, going forward, extra transparency. This is what Facebook always says, but it is not enough. Actually, we need to know about the past. It's really critical that we know about what happened in the EU referendum. We need to know what money was spent, on what, by whom. We need to know if that is lawful. And we need to know that everything possible has been done to find that out and to assure us that that result is safe. I think there is a danger here in what we're seeing in Britain of an almost systemic failure with regards to the referendum, because we're in a position where we know that our electoral laws did not work. They could not stop this panoply of behaviours which are now being investigated. And we know that the regulators, and I'm talking about the Electoral Commission here in particular, did not have the legislative framework it required. And we know that it does not have the powers that it needs to properly to properly sort of compel evidence. And we also know that it's too late. So the Electoral Commission has just referred Leave.eu to the police. This is 2 years from the event. And that police investigation, anything going to trial, is going to be well after Britain has left the European Union. So I think this is a real problem, and I think there is also a political failure here, because it's not just that the present government is so invested in Brexit at all costs that I think it's being willfully blind, but I think it is also potentially complicit, because two ministers in the current government, Michael Gove and Boris Johnson, were senior directors of the Vote Leave campaign. It is alleged that they had knowledge, full knowledge and understanding of this massive overspending scheme. Two political directors to Theresa May have been named as directly responsible for that overspending scheme. So I just leave it with you to say that I am genuinely troubled and disturbed by the fact that we may not have rule of law in Britain with regards to the referendum, and I urge you to look more closely into it. Thank you.
Thank you very much, Carole. Also, at the heart of the investigation in the United Kingdom and Cambridge Analytica was the Information Commissioner. Carole referred to her just now, Elizabeth Denham, and many of you will have been following this. She's accompanied today by the Deputy Commissioner as well, but I'm delighted that she accepted our invitation because it gives a completeness to the description of what is going on, and I'm delighted that you were with us today. So Elizabeth Denham, please take the floor.
Thank you to the Chair and to honourable members for inviting me to the hearing today. I am the UK's Information Commissioner, and in that role, I'm the supervisory authority for data protection law in the United Kingdom. My office, which is known as the ICO, is, I believe, the largest data protection authority in the EU by staff numbers and funding. We are a proactive regulator with an educational as well as an investigative role beyond just adjudicating data protection complaints. Specifically, in relation to the subject of this hearing, my office is leading the investigation into Facebook and Cambridge Analytica on behalf of our EU counterparts. There are some other EU data protection authorities that have active investigations into a number of different concerns related to Facebook. And I'm joined today by my deputy responsible for operations, James Dipple-Johnston, who leads the investigation into Cambridge Analytica, as well as our broader investigation into the use of data analytics for political campaigning. And we are appearing here today during an ongoing formal investigation. And therefore, there are some limits to what we can say, and some of the questions that you may put to me I may not be able to answer. That also includes responding to comments made by other panelists. I am happy to respond in more detail to the committee in writing when I am able to disclose further information. But first, I want to assure you and assure the public who may be watching that I understand your unease about how online platforms, including Facebook, are using our personal data and who they may be sharing it with. More recently, we've seen that the behavioral advertising ecosystem has been applied across political campaigning to influence how we may vote. And I'm deeply concerned about the fact that this has happened without due legal or ethical considerations on the impacts to our democratic system. And that's not to say that the online space is unregulated. Whenever online activities use personal data, then data protection law applies and can provide effective protection for individuals. Data protection is a fundamental right in the EU Charter, and CJEU case law has made it clear that online platforms are data controllers under data protection law, and they can be held fully liable for misuse of personal data on their platforms. These organizations have control over what happens when an individual's personal data, how it's used to filter content. They control what we see, they control the order in which we see it, and the algorithms that are used to determine this. Online platforms can no longer say that they're merely a platform for content. They must take responsibility for the provenance of the information that's provided to users. But I recognize that some aspects of our legal systems have failed to keep up with the unforeseen pace of the internet. In terms of data protection law, the GDPR is an important step forward for the law, and it's also an important step for data protection supervisors to catch up. The GDPR is written flexibly to ensure that authorities such as the ICO have the capacity to follow the data and establish who the data controller is, regardless of the medium in which personal data is processed. Data protection law and the reach of an authority like the ICO extends well beyond brick and mortar office premises. Data crimes are real crimes. GDPR fully equips us to thoroughly investigate crimes that may have taken place, even if they've taken place entirely online. As some of you may be aware, in May 2017, I announced a formal comprehensive investigation explaining my concerns about invisible processing, the behind-the-scenes algorithms, analysis, data matching, and profiling involving personal data that has taken place in political and referendum campaigning. In February of 2018, our focus on Facebook and Cambridge Analytica, only one strand in our comprehensive investigation, was heightened by evidence provided by Mr. Wylie, who you're going to hear from shortly. And it's against that backdrop of intense media and political interest that the ICO has continued its investigation. I've also given evidence to the UK Parliamentary Committee investigation on fake news chaired by Damien Collins. I'll turn to James.
It may be helpful if we explain for honourable members that we are taking a twin-track approach to our investigation. The first is to investigate specific allegations and conclude any enforcement actions necessary to comply with the law. And secondly, to produce a report about the wider implications of our investigation, including recommendations about gaps in regulation, both data protection and otherwise. We plan to publish this report before the end of this month. Our investigation is significant and wide-ranging. We have over 40 investigators full-time on the inquiry, plus external legal and forensic digital IT recovery experts assisting us. This probably adds a further 20 staff to the inquiry team. We are looking at over 30 organisations as part of this investigation and the actions of dozens of key individuals. We're investigating social media platforms, data brokers, analytics firms, political parties and campaign groups across all spectrums, and academic institutions. We are looking at both regulatory and criminal breaches, and we are working with other regulators, EU data protection colleagues, and law enforcement in the UK and abroad. Our work obviously needs to meet the civil and criminal standards of evidence gathering if it is to be useful. We have recovered materials, including dozens of servers and pieces of equipment, containing in total hundreds of terabytes of data, all of which needs to be carefully analysed. And this has come from searches of several premises and dozens of interviews with key persons. We have used the full range of our powers, including formal notice powers, our powers of entry under warrant, as well as our audit and inspection powers. We are looking at the complete range of sanctions available to us, including our new powers under the UK Data Protection Act, for no-notice inspections, a quicker warranting process, and to compel delivery of evidence, and where necessary, to seal digital evidence where it cannot be immediately recovered.
In this case, the spotlight is well and is truly on data protection, and I do recognize, no pressure, the incredible importance of the work underway. But this is a vital opportunity to assure citizens in the EU that where their personal data is misused, there is an effective regulatory response to help protect them. So where do we go from here? The issues raised by Facebook Cambridge Analytica case go beyond the remit of the ICO as the data protection regulator investigating this case. We will make recommendations in our upcoming report, the relevance of which extend well beyond the borders of the UK. Beyond data protection, I expect that my report will be relevant to other regulators overseeing electoral processes and also overseeing academic research. What is clear is that work will need to be done to strengthen information sharing and closer working across these areas. My main message for MEPs is to give the GDPR some time to operate. The investigation by the ICO is unprecedented in its scale, and we believe that it's the largest investigation undertaken by a data protection authority. The investigation is providing an early opportunity to consider the GDPR against the pressures and demands of a real-world contemporary case. Our investigation and action in this case will change the behavior and the compliance of all of the actors in the political campaigning space. Journalists, whistleblowers, advocates, and parliamentarians have played a key role in bringing these issues to public attention. What we now need is sustained willingness by citizens to exercise their data protection rights. We need regulators unafraid to use our tools, our sanctions, and our fining powers. And we need legislators supporting their data protection authorities to ensure that they have the capability and the capacity to deliver on their important role. So we're happy to participate and to answer questions, but I would ask the committee to consider that we are in the middle of a significant criminal investigation that goes wider than Cambridge Analytica and Facebook. And this may constrain areas on which we're able to comment. we are happy to inform the committees of this House at later stages of any developments, if that would be helpful. Thank you very much.
Thank you very much, Mrs. Denham, and we appreciate the restrictions you're under in what you can report, and also your offer to perhaps inform us at later stages in our hearings. Professor David Caroll, of course, filed the pivotal legal challenge in the UK courts to force Cambridge Analytica to disclose the psychographic targeting profile on him, and this is a critical part of the jigsaw, and we're delighted that he's accepted our invitation as a witness and participant. So, Professor Caroll, you have the floor.
Thank you to the Chair of the Committee on Civil Liberties, Justice, and Home Affairs for the invitation, the other committees, but also special thanks to Dr. Paul-Olivier Dehaye for recommending me, but also for helping me to begin the data quest that brings me here today, for teaching me about how data and technology and EU, UK, Swiss data protection laws intersect to protect democracies in the 21st century. It was through the suggestion to see if my voter data from the US election in 2016 would arrive by way of the UK Data Protection Act using a subject access request made in January 2017 and received in March that year, which I deemed insufficient. I instructed my solicitor, Ravi Naik of ITN Solicitor, on the matter of Cambridge Analytica, on the premise that my voter file couldn't possibly be complete and that we as an American voters had rights for full disclosure, and we should pursue those, and we did. Firstly, by filing an official complaint with the Information Commissioner's Office on or around 4th of July 2017, which incidentally is Independence Day in the United States. The complaint laid the basis of an inadequate disclosure of how my voter profile was sourced, generated, and shared with recipients. The response to this complaint was most recently expressed as an enforcement order against SCL Elections Limited, the registered data controller for Cambridge Analytica in the United Kingdom. This is after my complaint contributed toward the ICO's ongoing transnational investigation of voter analytics practices. It's a pleasure to be serving on this panel with the Information Commission today. It's the first time I've had the pleasure of meeting Commissioner Denham in person. I'm appreciative of the support and recognition of the general concept of data sovereignty. Because my data was processed in the United Kingdom, and I proved that through the subject access request, the law should apply regardless of citizenship. The ICO's enforcement order is due today from SCL Elections Limited. Unfortunately, we need to consider that the recipients of the order may not comply. What if their administrator does not take the most obvious route forward here and provide the ICO with the login credentials to recover my data on the seized servers so that the regulator can fulfill the subject access request on behalf of SCL? In any event, I have a claim that was filed in the High Court under Section 7 of the DPA on 16th of March 2018. Which also seeks to recover and repatriate my Cambridge Analytica voter profile. That claim remains ongoing. In both the complaint and the claim, we ask the ICO and the High Court to enforce SCL Elections' obligation to disclose a list of third-party data vendors and specific details of how my voter record served as a key to re-identify me in commercial data sets that must have comprised the source data to construct a model of my political beliefs and propensities. Despite numerous instances of Cambridge Analytica employees claiming to have assembled up to 5,000 data points per US voter, that includes a psychographic personality profile, the company did not disclose this fully despite the requirements of Section 7 of the UK DPA. Experts have advised the court, based on their analysis, that the data provided in the original subject access request response showed evidence that it was derived from data far beyond simple demographics contained in a voter registration record. This crisis, the focal point of which might be Cambridge Analytica, has exposed a new set of problems we could potentially call data laundering, where data is seemingly and reportedly illicitly misappropriated across boundaries and borders and used for possibly unlawful purposes, or somehow dirty data is mixed with other data to clean it, but then it makes the subsequent data models tainted. This is a new problem that the Cambridge Analytica GSR Facebook story demonstrates for us, And it's the reason why the story has rattled the world, even though it's difficult to explain why. Because almost all of us can agree that a data crime may have occurred, possibly a crime against democracy itself. Personal autonomy and national sovereignty are under siege, with only election and privacy laws in place as shields. I am here as a citizen of a nation that has not yet granted its citizens the necessary rights that we require to protect our democracy within new realms of micro-targeting that intermingle with information warfare. If I am unable to recover my own data out of the wreckage of this data spill, nor help others around the world recover their data, then we know we have work to do to fully protect people, especially when data crimes are possibly committed, and data might be destroyed without sufficient capture by the authorities, or when the entities attempt to liquidate liability. Continue to watch the Cambridge Analytica story closely to see if it is ultimately a story of evasion or accountability. By an idiosyncratic turn of events, U.S. citizens end up with data protection rights, thanks to European law. It has demonstrated to many countries the issues related to the protection of voter files and the data brokerage industry, the advertising technology industry, the social media industry, and its radicalizing recommendation engines, its individualized user targeting, and the military-grade vendors of psychological operations pitching to political campaigns, including SCL Group and the more recently revealed Psy Group, apparently offering false amplification and false news production for political clients seeking to weaponize disinformation for profit and power. These all intersect around the principles of data protection, privacy, and privacy by design as essential for democracy. These are the new civil rights, especially when we see that data crimes are potentially being committed and perpetrated against entire populations, the use of micro-targeting for macro effects. At least at last week's Facebook shareholder meeting, institutional investors revealed their anxieties around their investments. They asked themselves if their company is responsible for mass human rights violations. During my legal challenge to SCL and its affiliates, confirmed by whistleblowing, reporting, and undercover work, it has become apparent that the executives at the firm mistakenly believed that they were under the data protection jurisdictions of the countries they operated in, rather than in the UK where personal data was being processed as a registered data controller. In that way, countries with weak or non-existent data protection regimes, such as the United States, were prime targets for this form of commercial election interference. Indeed, having muscular watchdogs on the data crimes beat is an important deterrent to would-be election meddlers, tempting politicians with dirty tricks and privacy violations at scale. How did existing data protection regulation and regulators help protect democratic institutions in the EU from foreign influence and interference campaigns, even those potentially laundered through official campaign services? And how are the tools built by Facebook for advertisers and political campaigns alike, such as custom audiences and lookalikes, weaponized by not only state foreign actors, but also seemingly legitimate campaign vendors and their subcontractors and clandestine affiliates? In closing, I hope my remarks have offered insights to the committees from unexpected beneficiaries of the EU model of data protection, widely emulated around the world, its positive influence expected to grow after the GDPR. My story is a peculiar example of how the typically American deference to the tech companies and a reluctance to consider comprehensive privacy rules contrasts with strong data protection regimes enforced by muscular regulators equipped with the necessary tools, including criminal charges and seizure authority, to catch potential data misuse in the act and deter future bad actors from attempting to build increasingly sophisticated and invasive software, to combine data together, to manipulate electorates with the tools of marketing deployed with a militant mindset of selective voter mobilization and demobilization. Proponents of political micro-targeting insist it is a necessary tool for engaging with electorates. However, unless these political technology machines are built upon fundamental rights of access and privacy by design, it strains credulity that democracy can survive uninjured if we do not absorb the difficult lessons that we can learn from the Cambridge Analytica catastrophe. Thank you.
you very much, Professor Carroll. And finally, Christopher Wylie, of course, the whistleblower at the heart of this, and the former Director of Research at Cambridge Analytica. Thank you for being with us, and you have the floor.
Mr. Chair, committee members, thank you for the opportunity to speak with you today. This is my 5th testimony to a legislative body, but is perhaps the most important. People only act in a state of necessity, as Jean Monnet said decades ago, and usually only recognize such necessity in a situation of crisis. I'm here today to tell you that there is a crisis. This crisis is not just one of privacy, it is one that may have led to the EU losing one of its largest member states. What I bore witness to at Cambridge Analytica should alarm everyone. Cambridge Analytica is the canary in the coal mine to a new Cold War emerging online. I was the Director of Research for SCL and Cambridge Analytica from 2013 to 2014. SCL Group was a military contractor based in the UK. Cambridge Analytica was created by SCL Group with funding from Robert Mercer, an American billionaire based in New York. Robert Mercer installed Steve Bannon as CA's vice president with responsibilities to manage the company day to day. But it was not just America that concerned Mr. Bannon. He saw Britain as a key part of his strategy, and Brexit served as a cultural breaking point. The ethos of the firm was anything goes. I witnessed some senior staff even going so far as attempting to divert health ministry funds in a struggling African country to support a politician's re-election campaign. By taking advantage of countries with still developing civic institutions, the firm was a corrupting force in the world and became at the face of what colonialism looks like in the 21st century. Between 2013 and 2015, Cambridge Analytica funded a multi-million-dollar program called Project Ripon. The purpose of Ripon was to develop and scale psychological profiling algorithms for use on political campaigns. To be clear, the work of Cambridge Analytica is not equivalent to traditional marketing, as being claimed by some. This is a false equivalence, and it is misleading. Cambridge Analytica specialized in disinformation, spreading rumors, compromat, and propaganda. CA sought to identify mental and emotional vulnerabilities in certain subsets of the population and worked to exploit those vulnerabilities by targeting information designed to activate some of the worst characteristics in people, such as neuroticism, paranoia, and racial biases. This was targeted at narrow segments of the population. For those who claim that profiling does not work, this contradicts copious amounts of peer-reviewed literature in top scientific journals, including the Proceedings of the National Academy of Sciences, Psychological Science, and the Journal of Personality and Individual Difference. Even Facebook itself has applied for a patent on, quote, determining user personality characteristics from social networking systems communications. Dr. Alexander Kogan was selected to lead the data harvesting operation as he offered the use of his Facebook applications. Dr. Kogan developed data harvesting applications that would capture not only the original app user, but would harvest all of the personal data of that user's friends and connections without their knowledge or explicit consent. This feature was allowed by Facebook at the time. I later learned from correspondence with Facebook that Dr. Kogan did not have permission to exploit the app's privileged access for commercial or political activities. However, it should be noted that the app's terms and conditions actually stated that user data would be sold and transferred to third parties. Facebook was sent a copy of these terms and conditions in June 2014, prior to data harvesting. Facebook then approved the app's terms and conditions and allowed the app to collect this data with those terms and conditions. When questioned about the fact that Facebook approved the app's terms and conditions, the CTO of Facebook, in fact, admitted that Facebook, quote, did not read all of the terms and conditions. Ironically, this is a company that expects users to read terms and conditions when it does not even read the terms and conditions of its own applications. If Facebook had bothered to review Dr. Kogan's terms and conditions, things may have turned out differently. In late 2013, SCL Group helped set up a company called Aggregate IQ. AIQ developed the Ripon platform that harvested the Facebook data. AIQ's first project was in Trinidad in 2014, which was used as a testing ground before entering the United States. There, AIQ was contracted to acquire live internet service provider data to tacitly monitor the internet browsing habits of voters in the Caribbean without their knowledge or consent. SCL Group also sought out de-anonymized census data of individual citizens. In 2015, AIQ received videos from Cambridge Analytica for distribution in Nigeria as part of a voter suppression campaign. Those videos showed people being sadistically murdered, with victims being held down as their limbs were amputated and throats cut. In 2016, Aggregate IQ, the same firm, received 40% of Vote Leave spending during the referendum. Much of that funding went to Facebook targeting. AIQ received major contracts from other Leave campaigns, including Be Leave, Veterans for Britain, and the DUP. Vote Leave, in fact, donated £625,000 to Be Leave so that it could be used on AIQ services. In Britain, there are strict spending limits for elections. British law also forbids campaigns from coordinating as to prevent shell entities from becoming overspending vehicles. But this appears to be exactly what happened in the referendum. Vote Leave set up a new campaign entities and donated money to those entities via AIQ, which could mean that Vote Leave significantly breached spending limits during the referendum. The role of AIQ appears to have been a proxy for this coordination. Facebook has confirmed to the British parliamentary inquiry that AIQ set up identical custom audiences for Vote Leave and Be Leave's ad targeting, which means that personal data was shared between campaigns via AIQ. The firm is now under investigation for facilitating illegal spending and for data crimes committed during the referendum. When it was announced last year that the scheme was under investigation, Vote Leave accessed a shared drive of Be Leave and attempted to remove the names of senior Vote Leave officials from documents. After this story was publicized by The Guardian in March, Vote Leave again accessed the same shared drive and attempted to alter more names on user accounts. It appears they were trying to cover it up by tampering with evidence. The UK Prime Minister's office is implicated in this affair. Two of Theresa May's senior advisors worked directly on this financing and data scheme using Cambridge Analytica's affiliate AIQ. They know what happened, and they want to stall any public inquiry until they have secured Brexit first. This is not just about a minor spending infraction. This was the single largest expenditure of Vote Leave. It appears that the avoidance of electoral law and data protection law was the basis of Vote Leave's campaign strategy. Cambridge Analytica may have dissolved, but the European Union and its citizens will feel its impact for a generation. I do not believe Brexit would have happened were it not for the data targeting technologies and network of actors set up by Cambridge Analytica. I also do not believe that the Brexit result was won fairly or legitimately. Shockingly, British law offers no remedy. Were this a typical parliamentary election, a special elections court could be called, which would have the power to call a by-election if there were questions of electoral fraud. But there can be no by-election for this referendum because the legislation did not consider a situation of cheating in the Brexit vote. To be clear, we are in a situation where it is almost certain that systemic cheating and electoral fraud occurred, enabled by foreign companies funneling money into illegal data practices and Facebook targeting. Facebook's system allowed this to happen, and Mark Zuckerberg's refusal to answer key questions has prevented us from finding out everything that happened during Brexit. If this occurred in Nigeria or Zimbabwe, the EU would demand a rerun of the vote. Perhaps we should hold the UK to the same standard. The primary law of the European Union affirms its democratic norms. Article 2 of the Treaty of Maastricht confirms the foundational principles of democracy and the rule of law. Article 3 of the First Protocol of the European Convention of Human Rights reiterates the principle that where there is a vote, it must be free and fair. Brexit is not simply an internal issue for the UK. As a current member of the EU, the UK must conform to the democratic norms and rule of law. The EU therefore has both a right and an obligation to know if millions of people will be losing their rights as European citizens on the basis of a flawed vote, corrupted by systemic electoral fraud and data crime. This is not about arguing whether the UK should remain or leave in the EU. It is about upholding the rule of law, both in Britain and the EU. The UK is about to embark on the most profound change to its constitutional settlement in a generation. And for the first time, the EU is about to lose a member state. We therefore must be absolutely certain that this is being done on a proper legal basis without any questions to the veracity and validity of the vote. Facebook was first notified of Cambridge Analytica's data harvesting scheme in 2015. It did not warn users then, and it only took action to warn affected users 3 weeks after The Guardian, New York Times, and Channel 4 made the story public. Facebook's behavior before the story broke was to threaten and sue The Guardian. Facebook's lawyers also tried to intimidate me with aggressive legal notices. Facebook tried to shut down the story from going public when it knew it was true. At the British parliamentary inquiry, the CTO of Facebook recently explained, to the surprise of many in the inquiry, that the company had assumed that threatening journalists was, quote, common practice in the UK. I am disappointed that Facebook has not acted constructively in the wake of this scandal. Before the story broke, I offered to help Facebook. One of Facebook's vice presidents explicitly told my lawyers that they would welcome a collaborative engagement. But at the last minute, they instead announced in a press release that they had banned me from their platform in a bungled attempt to cast themselves as a victim. I remained banned from Facebook despite the UK Information Commissioner's Office confirming in writing that I am, quote, not a subject of their investigation. Facebook's decision to ban me from their platform was recently debated in the UK Parliament. Responding on behalf of the British government, the Secretary of State for Culture called the ban outrageous. Because it is outrageous. Banning a whistleblower reveals the unrestrained power technology companies have over users when a person's entire online presence can be so quickly and so thoroughly eliminated from existence. There is no due process, there is no check on this power, and my ban raises a serious question. What happens to our democracy when these companies can delete people at will who dissent, scrutinize, or speak out? Facebook's actions against me also show the serious consequences of Silicon Valley's rush to consolidate the ownership of different platforms. Although this scandal had nothing to do with Instagram, my account on Instagram was also eliminated in what I can only assume was a punitive move by Facebook, which now owns Instagram. This unchecked monopoly on digital space represents a serious risk to people's rights. Facebook demanded that I hand over my personal computer and phone after the story broke. The company disregarded that I had already handed over evidence to the responsible British authorities with jurisdiction over that investigation. In effect, Facebook was demanding that I let them handle evidence subject to an ongoing investigation. The company did not seem to care about due process or respecting the integrity of an ongoing investigation by a competent legal authority. Facebook also ignored the fact that I needed to access my Facebook account to provide further evidence to the UK authorities. My witness statement to the Electoral Commission on the events of Brexit is missing details because I could not access my profile, even after Facebook was made aware of this. The company did not seem to care that their ban was inhibiting this investigation. But as we've seen with Mark Zuckerberg's continual refusal to attend the British Parliament's inquiry, it is impossible for other countries like the UK, where these events have happened, to hold these companies to account. To highlight the seriousness of the matter, the British Parliamentary inquiry is now considering issuing a standing summons on Mark Zuckerberg after the company failed to answer 40 of the inquiry's questions. We cannot keep deferring to the technology sector with the defeatist mantra that the law cannot keep up with technology. We need a different mentality. Technology should not be exempt from public oversight or debate simply because it relates to software. Every year, Europeans are buying more and more internet-enabled devices and appliances. Soon, the so-called Internet of Things will become the norm in our households. Algorithms will be driving our cars, will soon be driving our cars and organizing our lives. The GDPR is a fair attempt at creating a regulatory framework, but it still has many weaknesses. The GDPR requires privacy by design, but what about transparency by design? We have no idea what actions or adverts are being sent out to users on social media platforms. If Facebook were transparent, we would be able to understand and scrutinize the targeting and messaging that occurs on this platform. Invisible data chains from interconnected systems also present a problem, and this will grow in the future of highly interconnected smart devices. Who or where is the data controller in a system where every device dynamically connects to the other? What exactly is personal data in a dynamic network of weightings, decision boundaries, eigenvectors, transformations, imputations, and inferences? As AI develops, we will need to rethink...
Do you want to close now, Christopher, please?
All right. I'll answer questions.
Do a conclusion, please. Okay, and now I'm the villain, and you're...
That's fine.
You get a bit, you
In
get more
conclusion,
applause.
there's lots of things that we can do about it. And it starts with you.
It's okay, I made you look good. I'm just about to really ruthlessly enforce the time of all of our members, so I just thought it might be fair to kind of keep everyone to time. Let's go straight to the questions now, colleagues. So it's 1 minute question from a painstakingly put together list, so please don't question it. Honestly, it's just, it's a list and it's fair, apparently. So it's 1 minute. When you do your 1 minute question, you have to specify which person you want to answer the question. And the person answering the question, you have 2 minutes, up to 2 minutes. It sounds draconian, but it's the only way we get through it. And we're not criticised by the world for what happened last time. Okay, so we begin with the committees, and Barbara Spinelli for the AFCO committee, standing in for the chair of the AFCO committee.
Yes, good evening. I'll ask a question on behalf of Mrs. Danuta Hübner, Chair of the Constitutional Commission. The question is to Mrs. Elizabeth Denham. Dear Mr. Denham, in this digitalized era, how can we as regulators strike the right balance between using the opportunities created by online platforms to connect and to inform voters openly about their choices and the risk that voters' decisions might be influenced in an intransparent and possibly illegal ways? Thank you.
Mrs. Denham for 2 minutes, please.
Yes, thank you. Thank you for your question. In the report that we're working on, it will be released later this month, we are very much aware of the value of social media and online communication for politicians and political parties to be able to connect with voters and to encourage democratic engagement. At the same time, this needs to be done in a fair and transparent way, and it also needs to be done in a lawful way. When we've interviewed all of the main political parties in the UK to talk to them about how they use personal data and data analytics to be able to target groups and individuals, our report will have a lot of detail about what's actually happening on the ground. They have also said to us that they feel that the technology has got ahead of the consideration of privacy and transparency and ethics in this space. So it's time to take an ethical pause and look at the processes and look at the use of data to micro-target individuals. We have to take the people with us. We have to make sure that we're not creating echo chambers where there's no way that we can have a public debate on an issue. So we're going to be recommending in our report an enforceable code for political campaigns, for political parties on the use of data and data analytics. And I think we're getting a lot of buy-in from the mainstream politicians and political parties for the kind of detail that we need to put in place.
Thank you. The Vice Chair of the Jury Committee, Laura Ferrara, please, 1 minute.
Thank you, Chair. Good evening. My question is for Mr. Christopher Wylie, even to give him the opportunity to continue with his speech. So the recent development of artificial intelligence raises a number of legal and ethical issues. To profile users, a large amount of content must have been extracted and analyzed. So could you clarify how this analysis was done in practice? And were there any discussion about the legality and ethical aspects of these actions in relation to EU citizens? Thank you.
Christopher Wylie for 2 minutes, please.
So just to understand your question, it was how was it done, and was there any consideration with respect to EU citizens? So a lot of data was acquired through the Facebook scheme that has been talked about, but also through data vendors and brokerage companies, and all of that information would be put together into what's called the database of record to create something called a single citizen view. So you see what people are doing online, you see what people are spending money on, where they live, if they take out a mortgage, etc. And then a sample of information where people would fill out psychological surveys would be then overlaid on that to look for relationships between that data. So that's how the algorithms were built, and those algorithms would then connect to Facebook's targeting platform to target specific segments of the population, depending on what the client wanted. With respect to consideration of EU citizens, I know that I raised several times the issue of the Data Protection Act, the UK Data Protection Act, and I felt like often that was ignored, frankly. So there was consideration, at least when I was there, at least on my part, to raise the issue of compliance with data protection regulations, with not just with respect to European citizens, but also the fact that we are processing in the EU, and therefore any person, regardless of citizenship, has those rights. But unfortunately, those were ignored.
Thank you. Mr. Sean Kelly, representing the chair of ITRE, please, for 1 minute.
Thank you very much, and thanks to the speakers, very informative. Just a comment first. We have a former employee of Facebook and Cambridge Analytica here. Was it not possible to get a current employee for balance and for authenticity? Questions mainly to Sandy. Facebook has said they're going to do an internal audit to see that other companies make similar data breaches. Is this adequate? Should it not be an independent external audit as opposed to an internal one? And also Mark Zuckerberg, because I worked on GDPR as a rapporteur when Vivian was proposing it, and I was in Silicon Valley a few weeks ago. And they're loud in their praise of the GDPR and saying that it should be made worldwide. And at the same time, we hear that they're moving the users in Australia, Africa, Middle East and Asia out of the scope of the regulation. So is there not a contradiction here? And what have you got to say about it? Thank you very much.
Thank you. Sandy Parakilis for 2 minutes. Thank you.
Thank you for the question. With respect to the first part regarding an audit of the applications or a number of applications that may have violated Facebook's terms, I agree with your assertion that this would be best done as an external audit. One of the major problems that we have in the technology industry is a lack of transparency, not just about how algorithms work, but also about business processes. So I would strongly agree that that audit should be done as an external audit by a party that is not being paid by Facebook. With respect to your second question, I'm not sure I understood the meat of the question. What was the key thing that you're trying to understand?
Seems we have seen references where Facebook are seeking to limit liability to GDPR by moving users in Africa, Australia, Middle East and Asia whose terms and conditions were previously linked to Facebook operations in Ireland out of the scope of the regulation.
So is your question whether that should be allowed under the GDPR, or why the companies are doing that?
They could probably argue.
We can't really get into much of a dialogue.
They could probably argue that as the GDPR only applies to the European Union, they need to do it. But at the same time, it seems to be a contradiction in the sense that they're praising the GDPR and saying it should be globally applied, where they seem to be moving all the people who were based in Ireland out of Europe.
Yeah, so I don't think that the way that it is being applied really is in the spirit of GDPR, nor in the spirit of what they have described, which is to apply the protections of GDPR globally. I think were they to truly act in that spirit, they would not have moved those accounts. And I think there's also an outstanding question of how do you define data, for example, in a message between an EU citizen and a non-EU citizen, where does that data live? So what I think will end up happening is all the answers to these questions will be resolved in the lawsuits that have already begun. So this will be figured out in court.
Okay, thank you. I extended the time there because it's crazy not to have taken a clarification. It just wouldn't have worked, so thank you for your patience. The next question is from Libe and the chair of Libe. The chair of Libe is here. He's the only chair that's here. That's nice. So I'll just ask my question. It's to Christopher Wylie. Well, it's good that some people attend, you know. That's good. Given what we know and what you've said, Christopher, about the impact of Cambridge Analytica on, I mean, you said about the UK Brexit referendum, but I want to ask about that, but also other potential elections. You mentioned the company Emmer Data. It's been established by many of the same people involved in Cambridge Analytica and its parent company, the SCL Group, and they've got significant overlaps of executives and financial backers. So my simple question is, what do you think is the likelihood of the continued use of the algorithms created by Cambridge Analytica, which have influenced the elections by profiling individual voters? I mean, what is your sense of this kind of multiplying effect on other elections as well? Because we have, of course, an EU-wide audience.
So, as I understand it, you have a two-part question. One, what will happen to the algorithms, and two, what effects has the company had in other jurisdictions? Do I understand it correctly? Yeah. So first, yeah, I am skeptical that the company is genuinely going away. I mean, it's taking, it's taking one hat off. But when you look at other companies that have been set up with many of the same people, it looks awfully suspicious. And when you consider the fact that tens of millions of dollars were invested into developing these algorithms and data sets, there would be potentially a strong financial incentive to keep that investment in some other form or entity. But obviously, I can't speculate as to what currently Cambridge Analytica is doing because I'm not there. With respect to other jurisdictions, the company has gone around the world and, in my view, corrupted fragile democracies and emerging democracies to exploit vulnerabilities in those systems for profit. And I'm encouraged, though, that there are some countries, for example, like Trinidad, who are taking it really seriously because they're looking at the fact that this is, in many cases, a new form of colonialism that happens with data online, where one country interferes with another country's internal processes. So does that answer your question, or is there?
It's going to have to be, because if I exceed time,
right.
I'll be
Got
launched.
it. Time.
So thank you for that.
Yeah.
For IMCO, representing IMCO, is Ms. Karatza-Bilt for 1 minute, please.
Thank you very much, Claude, and I would like to thank for these very chilling accounts that this careless behavior not only puts at risk our democracies, but also the election process and the referendums. In IMCO, we think that we heard too many times Facebook saying excuses that they apologize, that they were wrong, they were not careful enough, and we really think that commercial power has to come with responsibility. I also would like to mention that it's about better informing citizens, notify breaches of data, but also to remove illegal content online. So the questions are the measures, it is for Elizabeth. The questions are the measures and mechanisms that Facebook is taking to ensure that this kind of breach of data never happens again sufficient? During the hearing, Mark Zuckerberg, we heard a few actions. What is your assessment? Will that be enough? Second question, what measures should be put in place, if any, by the EU institutions to increase transparency? And third question, how can platforms better protect children online after the missed opportunity with GDPR? What Facebook is doing concretely to avoid profiling of children online, ensuring age verification and removal of content? Thank you very much.
Okay, thank you. That's to Elizabeth Denham for 2 minutes, please.
Yes, thank you. I think your question about whether or not Facebook's announced measures and steps to improve the record of the protection of data, are they sufficient? I think time will tell. I think there's more work to do. Our report and actions taken after our report, I think there'll be more that will become clear to you. But it's not just Facebook that needs to be more transparent and more clear and fair and comply with the GDPR and other laws. There are other online platforms that need to do a better job. But time will tell about Facebook. Again, there are many investigations underway among my EU data protection colleagues, and the European Data Protection Board has formed a working group to look at all of these issues. So I think that's important. Your second question is, what measures could EU institutions take? I think the GDPR, as I say, is an important first step. I think there's also ethical issues that have to be examined by EU institutions. And I know my colleague who is here, Giovanni Bertarelli, who's the European Data Protection Supervisor, has done a lot of work on data ethics. The UK is forming a new centre on data ethics because not all of these issues are black and white legal issues. So many ethical issues and grey areas need to be examined by institutions and also by parliamentarians. Your last question, how am I doing for time? The last question about children online. As you know, the GDPR does have special rules for children that internet service providers are supposed to deliver services for the age of children. It's interesting that in the UK, under the Data Protection Act, there is a requirement for my office to develop a code of conduct for the architecture and the design for children's services. I think that's a step.
Thank you.
Apologize.
No, it's okay. Representing the Cult Committee, Chair of the Cult Committee, Sabine Verheyen, please.
Sorry. Ja, zunächst einmal recht herzlichen.
Yes, first of all, thank you very much. Thank you very much for all of the information that you've given us so far, and also the very open way in which you've been responding to questions. I have one question, or perhaps two questions. For the Culture Committee, how can we ensure that the Article 10 of the Human Rights Convention, media freedom, is sufficiently protected so that despite the high processing of data, once people have given their agreement, which is legal, but can then be used to form opinions and be made available to people. So how, in this context, can we stop the forming of echo chambers which will influence people's opinions, and that this has an impact then on Brexit or other elections? And we've seen that there can be a huge influence.
Okay, you didn't refer your question to anyone. Can I give it to Carol?
I'm not sure whether or not it's for Mr. Wylie or Mr. Parakilas.
Mr. Parakilas is taking it.
I can attempt to answer this one. Thank you for the question. I agree that echo chambers are a huge problem that we face. And I think that the way that technology companies need to address that effect, and to be clear about the effect, we're talking about the effect of surrounding users with more and more views that they already agree with. So that is one part of the problem. A second part of the problem is when you do that, when you build algorithms that are optimized towards engagement, which results in echo chambers, it can also surface false information and conspiracy theories and a number of other related content problems. So I think there's two sides to this. One is the tech company side, which is they have historically not looked deeply enough at this problem, and so I think they are now actually looking more deeply at it, but there's a lot more work to be done on their side. And from a regulatory perspective, I think the primary thing that is needed is more transparency into both how the algorithms work and also what the outputs are. So requiring tech companies to report on sets of metrics that help define how bad the problem is will take us a significant way down the path of solving the problem.
Thank you. For Libe, Roberta Metsola, for 1 minute, please.
Thank you. Thank you for your courage in speaking out. This is an era where data is the new gold, and if there's something we can surmise from this debate is that unscrupulous politicians and those who support them will use and abuse our personal information to make propaganda appear as fact. Now, we have to examine what loopholes still exist. This is a scandal that is not only about misuse of data, but it's about systems that were built for the good that are being used against us. I come from Malta. Even there, Cambridge Analytica had a role, and we still don't know what purpose the data of 6,000 Maltese nationals and millions of EU citizens' data was harvested, and who ordered that to happen. Now, concretely, my question is to Ms. Cadwalladr, is what can we do on a European level to make sure that this does not happen again? And how can we help from this chamber whistleblowers and journalists going forward in your investigations? And then to Mr. Parakilas, what can Facebook do? Only one? Is that it? Okay, I'll give it to someone else. Okay, then I'll just add one question, like if you can. So what can Facebook
Roberta,
do
you should know
technically
better.
to prevent us from redoing this hearing again in a couple of years' time?
And you were looking at me for exceeding time. That was very cheeky. Right, Carol, 2 minutes, please.
So as I said in my introduction, I really think it's so critical that we find out what actually happened in the past. There is a seeming desperation by Facebook to just talk about the future and going forward. But I think unless we really fully understand what happened during this very critical election and exactly how our electoral laws were potentially, allegedly subverted, then I don't think we will be able to stop it happening again. And certainly that affects your future, our future, everything. So I would just urge you to really shine a spotlight on that, because I think I actually missed out a really crucial bit from my introduction, which is that all those investigations which are happening in the UK, multiple investigations by multiple authorities, they all connect through to Cambridge Analytica and its associated network of companies. And that all connects through to the owners of Cambridge Analytica, Robert Mercer and Steve Bannon. And I would urge you, again, just please ask questions of your own member who is not here today, Nigel Farage. I think actually he does have he could shine some light. And he will not answer questions from journalists. I have no joy whatsoever from asking questions of Nigel Farage's press spokesman. So please ask him that on behalf of us, if you would. Thank you.
Thank you. And for Libe, Birgit Sippel, for 1 minute, please, Birgit.
Thank you very much. And I have a question to Elizabeth Denham. Could you please explain once again to all the users which data are precisely processed by Facebook? So is it account data, content data, metadata when they use it? And what's the basis for then building up profiles, or what Facebook calls aggregated gate data that then are given to apps and like Cambridge Analytica and others? And as we learned from the revelations that those profiles or aggregated data can easily be used to manipulate people, or if I could say it this way, to buy a vote, to buy votes by using these profiles, which damages essential pillars of our democracy. How do you see GDPR and also the future e-privacy regulation restricting those practices?
Thank you. To Mrs. Denham for 2 minutes.
So if I may start, that is one of the issues we're looking at as part of our inquiry, exactly what data went where, from whom, and how that flowed through the system, how that data was combined with other data from other data brokers, what were the algorithms that were processed. We're presently working through a huge volume, many hundreds of terabytes of data to follow that audit trail, and we're committed to getting to the bottom of that, and we'll set that out in our report. In terms of what can be done more widely under the GDPR, I think there are already strong powers in the GDPR to allow data protection authorities to follow that audit trail. Our new powers of inspection, our powers to examine algorithms in situ while they are operating within a system, to be able to see how they are operating on site, are really important. And our powers of no notice audit means that we can attend, examine the premises, examine the infrastructure, understand how those data flows are being made, and as the Commissioner said, follow the data flows through the system. So I think the GDPR is a start, but it's something that we will continue to evolve and develop.
Thank you. The next coordinator for Libe from the ECR is Helga Stevens.
Thank you, Chair. The topic of this meeting is the Facebook scandal and Cambridge Analytica. But I'm not so sure if we should artificially limit ourselves to this case alone. Ms. Denham, my question is for you. As the UK Information Commissioner, could you tell us if this scandal is an isolated case or if other bigger and smaller platforms are doing the same thing, namely collecting data of users that have not necessarily given their consent, and then either selling that data or allowing targeted ads based on personal profiles on their platform? Companies must not be allowed to divulge EU citizens' data to third parties without explicit consent. And the second part to my question is, do you think that the GDPR will change anything? Or will GDPR impose itself on smaller players while the bigger ones find ways around it? I know a previous colleague asked a similar question, but I really want a specific answer to this question because it's important to us. Thank you.
Thank you. And again to Elizabeth Denham.
You asked me if I thought that this kind of activity that we're speaking about today involving Cambridge Analytica and Facebook is happening on other platforms, or if there's other applications, or if there's misuse and mis-selling of personal data. I would say yes. Even in the political arena, there are other political consultancies that are pairing up with data brokers and other data analytics companies. I think there is a lack of transparency for users across many platforms. Facebook is a very big player in this field and is the focus of misuse that has been identified in the UK. So yes, it is happening elsewhere. I think data protection authorities, I think parliamentarians, users, advocates, journalists are live to this, so I think it's a very important moment for data protection. Your second question is about whether the GDPR will change anything, or will it actually be a burden on small businesses? I think the GDPR is an important step. It's one step. But remember, the GDPR is the law that's written, the regulation that's written on paper, and what really matters now is the enforcement of the law. So it's the activities that data protection authorities are willing to do, it's the sanctions that we look at, it's the users and the citizens who understand their rights enough to take action, because we don't have thousands of inspectors that are going to go around and look at every system, but we do have millions of users and millions of citizens that can exercise their rights. So it's the enforcement and the administration of the law. It's going to take a village, I think, to change the scenario. And GDPR, again, is not about small versus large organizations. I think that data protection authorities are going to be proportionate in the way that they administer the law, and that certainly is true for our authority.
Libe Coordinator for ALDE, Sophie Intervelt, please.
Yes, thank you, Chair. Very quickly, first to Mr. Wylie. The European Commission wants to hire a company, Palantir, for the EU interoperability project. Palantir has ties with the CIA, and according to your statements, Palantir also worked with Cambridge Analytica. Do you think it's a wise choice of the Commission? Then to the ICO, we noticed that Europe is the new hunting ground of Steve Bannon. He even has allies in this House, mainly in ECR and ENF. And the US ambassador to Germany yesterday stated in Breitbart that he wants to help conservative forces win elections in Europe. What will the ICO do to make sure they cannot use illegitimate methods, and will it be quick enough if you intervene? Thank you.
That question's to two people, but thanks, Sophie. Okay. Honestly. Right. Mr. Wylie first.
So just to be clear, my question was with respect to Palantir. Is that, yeah. Yes, there were Palantir staff who came into the Cambridge Analytica office and worked on many of the projects that I have described whilst I was there. It's probably not my place to tell European institutions who they should contract with, but what I would say is that what this has exposed is that just because you have one company working on one thing and another company officially working on another doesn't mean that their staff under the radar as Palantir puts, in a quote, personal capacity, are working on data and are sharing information. So I think my recommendation would be to create mechanisms to ensure that any company that's working on a project is transparent with who they are working with, but also what their employees are working with on the side.
And for the rest of that 2 minutes, Elizabeth Denham, exceptionally, because they were good questions.
Yes, just to be clear, it's not just the ICO, but it's the responsibility of all European data protection authorities to be on their toes on these issues. I also want to say that the issue is algorithms as well as source data, and under the GDPR and the new tools, we'll be able to use enforcement notices to require companies to delete algorithms or to stop processing. And I think orders to stop processing are going to be as powerful, if not more powerful, than administrative fines.
Thank you very much. Libe Coordinator for GUE is Barbara Spinelli for 1 minute, please.
Una domanda per...
Thank you very much. I've got a question for Carole Cadwalladr, and it's a little bit going in a different direction to everybody else's, and some doubts about Cambridge Analytica and others. Now, Mr. Wylie says that the targeting of people was to do with what was happening internally, and he mentioned the American vote and Brexit as well. Now, I do understand the concerns, but reliable data does seem to say that what happened was less than has been said, was not as important as has been said. And what about what happened with Obama in 2008 and 2012 and the way they did things which the mainstream loved about? And so perhaps people are confusing issues here with authentic users. Cambridge Analytica supports or has supported Ted Cruz, but they're wrong about that. And there are questions about the reliability here, but I just wonder whether people aren't actually using this scandal to undermine analysis of their own defeats. Thank you.
Carole, please, for 2 minutes, yeah.
I think it's a really valid question about how effective the techniques are. But I think a bigger question is, was it lawful? And the thing I think I keep coming back to here, which is that when people said to me, don't all firms do this? Isn't this what all political campaigns do? I don't know of other political campaigns which use the services of a military contractor. So SCL Group is a military contractor, and it worked for the British government on contracts for the Ministry of Defence. It was paid by the British government to undertake propaganda exercises in countries abroad. We don't know quite what they did because that was classified. And the technology and the techniques that they refined doing that work were then turned upon domestic populations. And I don't think that is normal. And the question of how effective it is, well, that is a question other people can debate, but that's really not my focus. My focus is, was that done lawfully? Was it legal? How much money was spent? Who spent it on? why were these links between all these companies and between all these campaigns hidden? Why were they hidden? And I'd like to say, actually, because there's another person here who can also supply some answers, I think. You have the leader of UKIP is sitting here today. And UKIP supplied data to Cambridge Analytica that was used during the referendum. And UKIP, I understand, isn't complying with the Information Commissioner. And we don't have the power to question UKIP in the British Parliament because we don't have any representatives there. You do. So on our behalf, I really hope that you'll be able to ask some really interesting and insightful questions on our behalf. Thank you.
Okay. Okay. The Libe coordinator for the Greens is Jan Albrecht. Jan, please.
So I can try to just work as a relay now to take Mr. Cadwalladr's questions and give it back to Mr. Wylie, because I really think that it is about really understanding the facts of this case. And I would really, Mr. Wylie, understand a little bit more in detail what was exactly the Cambridge Analytica model for targeting ads on Facebook around the Brexit referendum, for example, based on which data models, what was this working, also including the subsidiary of Cambridge Analytica, Aggregate IQ, and their involvement in these campaigns. What are the data models, and what are the data which you worked on, and what was the targeting model behind it? If you could elaborate a little bit more in detail, because I think that's where we really need to understand a bit more what happened in the past. Thank you. Thank you very much.
Thank you. Mr. Wylie, please.
So it's hard to speak in detail due to the time limit. So what I will say is that you can refer yourself to the copious amounts of peer-reviewed academic literature that Cambridge Analytica based its work off of. Some of that research that was done at Cambridge University was funded by DARPA, which is the U.S. military's research agency. In terms of its effectiveness, at least whilst I was there, I definitely saw uplift in conversion metrics in controlled trials. So I do think that it does work. With respect to comparisons to the Obama campaign, I'll just say two things. The Obama campaign used data, but it did not use data to suppress voters, and it did not use data to manipulate or coerce voters, and it did not use data to disseminate disinformation. Yeah, unfortunately, the time limit prevents me from actually elaborating on how the models work, because that would take several minutes. So,
I apologise. Time limits have some limitations, but I'm sure you can expand in some other way. Thank you for attempting. Next is for Libe and AFCO, and for the EFTD is Mr. Batten.
Thank you, Claude. I've spent the last 26 years in active politics trying to persuade people that Britain should leave the European Union. During the referendum campaign, I was out every single day talking to what must have been hundreds, if not thousands of people face to face. Not one of them then, nor anyone since, on whatever side of the vote they were, has said to me that they were in any way, shape or form influenced by anything they saw on social media. This whole thing is about the Remain establishment doing everything they possibly can to reverse the referendum decision. And my question is for Carole Cadwalladr from The Guardian. Now, The Guardian is not an impartial commentator in this, but very much a partisan political player, just as much as any political party or any campaign group. My question is in two parts. Number one, has or is The Guardian investigating the Remain side of the campaign for the use of data or any other aspects of the campaign in the same way that they're investigating the Leave side? And number two, is The Guardian stand on this merely a purely politically partisan one in its own intention to assist in any way that it can to reverse and overturn the result of the referendum?
Thank you for your question. This is not a partisan issue. I cannot say that more strongly. This is about the integrity of our democracy. It's about our national sovereignty. And I would think that you would have an interest in that also. To go to your question, is the Guardian investigating the use of data on the Remain side? I am unaware of any issues on the Remain side. There is none that I have come across. There is none that I understand that the Electoral Commission has come across and is investigating, or that the police is investigating. If there are, then I very, very much hope that journalists will uncover this and it will be investigated. I think it's really important that it doesn't matter who is committing crimes or trying to subvert our electoral laws, that they are brought to justice and we find out the truth of them. We're in complete agreement with that. To the idea that this is a politically partisan motivated investigation, I don't think Facebook or Google are politically partisan in this. I think that they impact and affect countries and democracies, all political stripes, all over the world, certainly across Europe. And I think if you want to bury your head in the sand and believe that this is the remaining establishment, then so be it on your head, because let's see where that gets us. Really, 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 you've got to look higher and really see the bigger issue here and the bigger picture and the bigger risks to us all.
And for IMCO and ENF is Mylene Trzynski. 1 minute.
Merci beaucoup.
Thank you very much, Mr. Chairman. I had hoped to put a question that was similar to Mr. Batten's question, but what I'll do is I'll concentrate on a technical one, really to Mr. Parakilas. Well, I'll leave it up to you. I am aware of the very particular conception that Facebook has of personal data when there was an IMCO visit to Washington last year. The analysis of personal data collected by social networking platforms treated by algorithms is a technique which can, and why not, be used for electoral purposes. But not only that, the commercial use of our personal data is sometimes going to cause our hackles to rise. It's terrifying, really. You could well imagine that Facebook or one of the others listens into us or reads our mails. Now, the technical question, is there a fundamental difference between the techniques for exploiting the data used in the Trump or Brexit campaigns or the ones used commercially?
Sandy.
So I believe that the core question there was is there a difference between the techniques used by the Trump campaign and those used commercially? And the answer to that is no. I think what the Trump campaign did was that they very effectively used the commercial marketing techniques that have been developed for social media over the last several years, and they used them for a political campaign. And they used them very, very effectively. It was perhaps the most effectively run social media campaign for a presidential election ever.
Thank you. For Libe and the EPP, Livia Jaroka, for 1 minute. Thank you.
Thank you, President. A very short question. I would like to go back to whether we can know what economic profit Facebook has earned. Are there any third parties in this? And I would also like to know, is this happening in other countries? So political campaigns or governments pay, that these techniques are used for political campaigns or by governments. Thank you.
Olivia, to whom was that addressed, that question? Just give a name. Okay, we'll go for your first choice, Carole Cadwalladr.
I think, can I pass it over to...
She doesn't want your question. Who is it going to?
Sandy. I will be happy to answer your question.
I really think David's feeling a bit left out, so just bear this in mind in your future questions.
So the question was around the profits of political campaigns and whether there are third parties involved and what Facebook's profit is. So I can only speak generally here because Facebook doesn't break out their financials for political campaigns in general or for specific campaigns. That being said, there are sometimes third parties who are involved in the execution of a marketing campaign on Facebook, and so those parties receive some portion of the spend. But in general, either the majority or the totality, all of the spend on Facebook's platform for advertising goes to Facebook. And the reported number for example, the Trump campaign for the presidential election on Facebook was something in the order of 80 to 90 million US dollars, to give you a sense of scale.
Thank you. Just a reminder, colleagues, if you leave and your questions comes up, that's it, it's gone, it doesn't come back. For E-Tray and the S&D, Eva Kiley, please.
Thank you so much. I would like to address to Facebook this question. Is it technically possible to fully own our data, to export, delete them, to see who uses what, for how long, to grant or deny access to third parties, like device manufacturers, but still be able to use the application, so basically to have more options? And if you believe that this would be fair, and did you measure the influence of content of newsfeed, and the realization of its power led you to not manipulate the newsfeed by default or not? And finally, do you believe aggregated data should become a public good, especially for science, but also if you have any ideas or suggestions for us to avoid similar situations, that would be really appreciated, since law and like GDPR is a bit slow in order to allow innovation to happen, and it seems that for targeted advertisement we need new rules. Thank you.
Just to be clear, they don't work for their respective companies anymore. So just, I know, no, you just mentioned to Facebook, so. Or, no, just for the record.
Thank you for the question. There was a lot there, so I'm going to try to answer those three parts. So the first aspect was about control that users have. So Facebook, due to its being subject to a number of laws, not just in the EU, but in other countries as well, does provide a number of controls. However, one thing that has come up repeatedly is that in some cases those controls have not actually functioned the way that they have portrayed them to function. So one specific instance that was reported on this morning was that as you mentioned, in the case of device manufacturers who were allowed private access to data, including friend data, the setting that did not work was a setting that users have to turn off the ability to have their data accessed through friends. So in this particular instance, when the New York Times ran a test, that setting to disable platform access did not work, and the data of those users were still passed. So that is an example of a setting not working as expected. There are other examples, and it was subject of one of the main subjects of the FTC consent decree in the United States. Your second question was about newsfeed and whether concerns about content in newsfeed, or what are concerns about content in newsfeed. I think that the main thing to remember about newsfeed is it is trying to simultaneously pick the best content that users will engage in and also help a company like Facebook or Twitter or any other newsfeed company make money. And so one of the main problems that those companies have is that they have designed news feeds to be incredibly engaging, and that leads to a number of problems. And in the interest of time, I'm going to try to very quickly answer this question about aggregated data. I think aggregated data is a massive and very difficult problem that it's hard to answer in -5 seconds, but it is something that, based on how easily data sets can be de-anonymized, it's something that's going to bear a lot. We're going to have to think a lot about it as we look forward.
For Libe and Aldi, Peter Jezik, please.
Thank you, Chair. For me, the key question is how to shift the balance of power back from platforms again in favor of people in order to have fairly elected representatives and fair referendum results. So my question goes to Mr. Sandy Parakilas. Facebook's Mark Zuckerberg says weaknesses were addressed. However, we know that the key elements, algorithm, targeted ads, technology of persuasion, they still remain all in place. So how can misuse be prevented next time? And what needs to be done to prevent, again, stealing of election? What we've heard about Brexit, it seems to me like the robbery of the century. Well, thank you.
So I think there are a number of aspects that need to be addressed, both on the tech company side and the regulatory side. On the tech company side, I think Facebook is taking the beginning of a very important step right now in implementing transparency for advertising so that we can understand who is buying advertising around elections. I think that's really, really important. I think they have done a significant step, although not all of the things they need to do yet to provide that transparency. One of the major problems, however, on the tech company side is that the business model of these companies is to collect as much data as possible so that they can offer incredibly targeted advertisements and to sell those advertisements to the highest bidder. And this creates some really dangerous incentives that are bad for society. That is the simple truth of where the sort of surveillance advertising business model has taken us. And so there are two approaches we can take. We can either highly regulate all of the worst cases, for example, foreign actors interfering in elections, and we can write a bunch of very complicated rules about how that should or should not happen. Or we could simply remove some of the functionality so that there is less targeting capability, and so it's harder to do the kinds of things that happened in Brexit and in the US presidential election. So those are the two basic approaches. As regulators, I would encourage you, where possible, to try to avoid highly specific rules if you can avoid it. Where you can, try to think about ecosystems and incentives, and wherever you can, try to find other actors, like I mentioned with the insurance companies earlier, try to find other players in the ecosystem who can provide balance. So I know that's not an incredibly specific answer. It's a very complicated question. That's my general guidance.
Thank you very much. And for the third time, but there is a reason in a third capacity, Barbara Spinelli for Libe and GUI. You can explain why you're speaking for the third time, Barbara.
I have a question for Mr. Sandy Parakilas in Italian. Il nuovo regolamento della
The new GDPR regulation is a very precious instrument for our citizens. And I would like to ask whether the multiplication of European laws which are there to protect us could have a risky effect on the freedom and pluralism of the internet and also on the simplicity of access, how easy it is to access. You mentioned that. So a war against fake news, copyright law, codes of conduct for the huge companies of the internet on content. My impression is that we are trying to put the toothpaste back into the toothpaste tube, and that is just not possible.
I agree that there's a toothpaste and tube problem here. It is very difficult to go back and solve for products that have already been built and shipped when no one has thought about the potential negative consequences of what can happen when you build the product in the first place. So what I would encourage you and this body to do is to think broadly about how you can create incentives for companies to do the right thing and also to not do the wrong thing. And I think, you mentioned GDPR. I think one of the key things about GDPR is that it has meaningful penalties. For the first time, tech companies are having to face the prospect of really painful fines. And the really important thing about that is when you change the financial position of companies through the threat of a significant fine, they will suddenly reprioritize how they do business to avoid the toothpaste situation that you mentioned, because they don't want to be stuck with a multi-billion-dollar fine. So I would encourage you to continue to think about the financial incentives and disincentives and not be afraid of fines, but also ensure that you think about smaller companies and ensure that you're protecting companies that are doing new and innovative things, while also ensuring that the big companies are responsible for the kind of oil spills that they create.
Thank you. For Libe and the Greens, Judith Sargentini.
Thank you, Chair. And my question goes to Ms. Cadwalladr. And I would like to talk about the influence of the Kremlin on the Brexit referendum. I'm from the Netherlands. We had a referendum on the Ukraine. For us as well, the issue of influencing our campaigns during the referendum has been an issue we're worried about. I would like to understand what your opinion is there. How strong do you believe the Russian connection was in the campaign for the UK to leave the European Union? Who do you think were the key actors? And I also understand that you got personally attacked there. Are you personally safe? Would be my final question.
Thank you very much for that question. I think the really key thing is that we just don't know. So the suspicion is, of course, is that Russia did have an impact in some way in the Brexit referendum, because we know that it has interfered in elections all across Europe. It would seem this crucial vote, it would seem highly unlikely that it didn't at least try. But there has, again, this comes back to the political will issue and what I was talking about, what feels like a kind of systemic failure to grapple with the questions raised by these multiple investigations into the referendum. I think that we desperately need more information. One thing we do know is that Facebook has been obstructive in its efforts to help the British Parliament investigate this matter. So one thing we know is that in response to requests from Damien Collins, the head of the parliamentary committee who's investigating this, Facebook wrote a letter at Christmas time and said that they'd looked at the known accounts, and this is just a tiny fraction of known accounts from the Internet Research Agency, and it said that they had found $1 of spend during the referendum. And then 3 weeks ago, Congress went and published all those advertisements, and we got to see them. And we got to see the ones which were also targeted at Britain. And in that collection of advertisements, we saw that actually there was more than £1,000 which had been spent, which again, still doesn't sound very much, but it's a factor bigger than $1, certainly. And that was this was this Facebook very narrow interpretation of impacting. Oh, okay, I better go. But we please just, you know, we need more, and we need you to help us, because Britain is struggling to cope with these questions, and we need your support in this.
Thank you. For AFCO and the EFDD, Mr. Zullo.
Sì, salve.
Thank you. Good evening. I've got a question for Sandy Parakilas. Today, we've spoken about the GDPR, which is a real step forward when it comes to personal data. And in the discussion, a number of different solutions have emerged to make progress in the legislation, having transparency in the use of data, how data is passed on, and to give greater powers when it comes to the burden of proof, and to have penalties as well if necessary. So over and above the GDPR, in IMCO we were also talking about data personal data flows. And I think we do have to be very careful here, because we're talking about non-personal data, a message, for example, something that isn't personal. It can still say an awful lot about us. So, Mr. Parakoulas, in the light of your experience, what other suggestions might you have for a legislative framework that wouldn't actually put the brakes on the development of healthy companies, but also something that isn't just for the large companies, but for smaller ones as well?
Thank you for the question. I think that the key points I would reiterate are the same points from my presentation, which are, basically thinking about incentives, thinking about protecting smaller companies, and to give a bit more detail on that, I think you can do that in a number of ways. You can exempt them from certain rules, depending on the rule that may or may not make sense. You can reduce penalties. You can also think about education and support. I think that's probably an aspect that's not necessarily at the fore of people's thinking, but in fact, if you are trying to become compliant with GDPR, and I've seen this with a number of people I know in the US, they spend a lot of time and effort becoming GDPR compliant, and the more education support that can be provided in terms of providing specificity and resources to help smaller companies, the easier time they will have being compliant. So I think that beyond the stuff that I've already said, I think that's probably the area where I would expound the most, which is simply like think hard about how you can help small companies beyond simply reducing penalties. Think about how you can proactively help them engage and become compliant through resources that you can provide.
Thank you. For Libe, Jury and the EPP, Axel Voss, please.
Vielen Dank, Herr.
Thank you very much, Chair. I'd like to put a question to Mr. Parakoulas, please. And now, if we look at the case of Facebook and Cambridge Analytica, we as politicians are first of all shocked, and then we always say we should have stricter legislation, we should have other laws, etc., etc. And so I would just like to hear from you. Is it not, as I understood from Mrs. Denham's response, that more control is needed, more supervision, more law enforcement? That is what we need rather than additional legislation. So is it a question of supervision and control, or do you think that we already have to take a different step? And then my second question is, what do you think would be possible in legal terms, technical terms, to avoid abuse or manipulation of data? How do you think we could adopt legislation that would prevent that? Thank you.
So in terms of your first question about effectively enforcement, I'm not an expert on European data protection and enforcement. What I can say in general is that there has been, certainly in the US, almost no enforcement of even the existing law around some things like the FTC consent decree, for example. And so simply taking the first step of ensuring that the agencies that are enforcing these laws are well-resourced and are encouraged to actually, enforce on violations of the existing law would go a huge way towards addressing some of the things that have happened. Again, I'm not a lawyer, but I find it hard to imagine there have not been a number of violations of the existing law in the case of Cambridge Analytica and Facebook. So that's with respect to enforcement. With respect to new regulation, I think that the GDPR is in fact a really important first step. And what I would say beyond that is that there's going to have to be a lot of thinking that is done about the next generation of technologies. And so while I think GDPR does a admirable job of addressing some of the issues with current technologies, the stuff that's coming is, frankly, when you think about the bad cases, is terrifying. Things like deep fakes, the ability to create on-demand content that's completely fabricated but looks real, looks like real people talking, but they never said the things that are being said in the content. Things like artificial intelligence, which can predict user actions before those actions are actually done. And in fact, Facebook is just one company that's working on this, but the fact that they have a business model where they could potentially sell the ability to influence future actions using these predictions. There's a lot of thinking that needs to be done about the frameworks for these new technologies. And so I would just encourage you to engage as soon as possible on those new technologies so you can do that.
For Libe and the S&D, Joseph Weidenholzer, please.
Thank you. My question is to Carole Cadwalladr. Thank you for sharing your story with us and for the passion and the persistence you are doing this. What you uncovered goes to the very heart of our democratic societies, how to protect people from undue interference with their personal lives and, as we have seen in the context of Brexit, with their future. So my question is, what can we do to ensure that our democracies can survive, to put it so pathetic, by protecting citizens from any kind of electoral manipulation? And where do you see a lack of legislation? Where is there a lack of enforcement of existing rules? Thank you.
I think one of the things I want to address, which came out in a question before from Jared Batson, is that he said that nobody he spoke to had been changed by anything that they'd read or seen online. And I think the point is, certainly in the referendum, is a lot of people had very fixed views. But there was a tiny sliver of people who didn't, and these were the persuadables. And everything was about finding these few people. It's a few thousand people, essentially. And then you find them, you locate them, and then you bombard them. And this is the thing which was invisible to all of us. And it's the thing which is going on in elections in your own countries, I'm sure. And so there's this massive complacency, I think, amongst people to think, this doesn't affect me. I didn't see this. It had no impact. And it's really, really thinking about how to protect these people and making sure that this isn't happening in darkness. And that's the thing. This is all happening in darkness. And so, I think what you're doing is tremendous, and this just shining a light upon these practices and really thinking about what you can do to safeguard things going forward, and learning perhaps from, for example, what Elizabeth Denham has found out in her investigations and taking that on. Because I think complacency and some of the comments we've heard here is very dangerous. And it feels, so this is, you've got this, I was just really struck looking around and seeing everybody with their headphones and so many different languages being spoken here and so many different cultures. And what's been going on is this whispering in the ear. And it's not necessarily political. This is the thing, these advertisements. It's about stoking hate and divisiveness. And so I think you've got to look beyond the sort of like, these are political messages. There was something going on, a much broader, and I need to shut up now, my time's up, sorry.
Should be very neutral, but I like that answer. I'm going to get killed now. Okay, next for Libe and ECR is Mr. Jurek.
Dziękuję bardzo. Ja mam pytanie do pana Parakilasa.
Thank you very much. I have a question which is as follows. I'm concerned about the control of statements by Facebook. We've heard that pages are being eliminated, that it is not entirely possible to follow that up. And I wonder whether this is something that Facebook has been pursuing. Is this a clear practice, or are there rules about what can be eliminated, deleted that is, and what can we do about it to avoid this censorship operated by Facebook? And if there's still sufficient time in your answers, then I'd like to put a question to Mrs. Denham. In which other electoral campaigns have we, do you think, seen a similar abuse of personal data?
Elizabeth, please.
Your first question was about the deletion, perhaps illegal deletion of data from Facebook. And I would have to get a bit more context to be able to answer that question, whether it was somebody's profile information or evidence or administrative information. So I would need clarification on that.
Thank you very much. Now we go to Mercedes Bresso for AFCO and the S&D, please. 1 minute.
Grazie, Presidente.
Thank you very much, Chair. I've got a question for Carol, please. The problem is that about 10% of the world's population have an account on Facebook, so it is the world's largest public space. And all the democratic rules of the organization of this space are going to be essential in the future. In our democracy, we have rules based on representation enshrined in our constitutions, but it's very difficult to know quite how to be in that particular global space. So on the one hand, these recent attempts made by Facebook to try to impose their own limits on this abuse, how serious is that? Is that enough? And then also, on the other hand, many have asked this question, do you think that there has been influence on other elections? I'm thinking about the recent Italian elections, for example, but in other countries. And don't you think that an international network of investigating journalists would be effective in trying to counter this phenomenon? Thank you very much.
Thank you for that question. It's actually something very interesting I think you brought up there, which you've talked about. There's this public space which is used by vast swathes of the world's population. But that's the key thing. This isn't public space. We treat it like it's public space, but it's private, corporatized space. And I think this becomes very clear to anybody who has found themselves a subject of abuse on any of these platforms. And so I can refer to there was a question earlier about threats that I'd had, for example. And I can use this as an example because there was a threat made by Leave.eu, Nigel Farage's campaign against me on Twitter, where I was threatened with violence and with a gun in this spoof video. And hundreds of people complained about it to Twitter, and it did not come down. And there was not grounds to bring it down, apparently. So, and if this had been in the street, then I could have taken it down, I could have reported it to the police, I could have done something. But I think this is really, really key to remember. This is private space run by a private company. That is unaccountable. That is currently, Facebook is currently refusing to answer to our national government. It is refusing to come to Britain to answer these questions about what it did during the referendum. You are literally the only body in the world, potentially, that does have the power and the authority to get questions out of Facebook. And we just really, really, really need you to do that, I think.
And now from AFCO and the EPP, of course, the commissioner that was around when we did GDPR, Viviane Reding, please.
Well, thank you, Chair. My question is for Madame Denham. In the logic that, yes, GDPR is all about implementation and about enforcement. And so the role played by the DPRs is of absolute importance. We are waiting with great interest the report you are going to publish at the end of this month that you have said. But because we see that Cambridge Analytica is somehow the tip of the iceberg, I am wondering if other DPRs in other member states are doing the same in order to see what's happening in their place. Because we need to take action in our political parties in order to save the electoral process, which I think is really put into danger. So a report like yours can help. but it must not be only a British report. It has to be taken over, if necessary, by the umbrella of the DPRs. What's going on in that respect?
Thank you for that question. We are leading the investigation into Cambridge Analytica and Facebook because of the connection to Britain. And certainly the resources of our office, because we are one of the most well-resourced offices, we're able to take that on. And my colleague James explained the scope of the investigation and the numbers of staff that we have to put to that. There's very few data protection authorities across the EU that can pull 40 investigators plus external counsel and digital forensic experts together in a very short period of time. So I encourage you to make sure that your data protection authorities in your member states are well-resourced and have that capacity. The recommendations that will be in our report can be read across to similar companies and similar practices in other member states. And we're working very closely with the European Data Protection Board, with a new working group on online platforms and social media. So we are working together, and I think that's a good use of resources, but it certainly isn't a British report, because remember, it is focusing on Facebook, on data analytics companies, on data brokers, on campaigns and political parties. So I think it does have wider application and wider scope than just in the UK. Thank you.
I think this is an important point. The events happened in the United Kingdom with British elements, but clearly the lessons must be more widespread. And thank you for making the point crystal clear. And the further hearings will make this very clear too. We have 5 speakers to go, and the interpretation finishes at 8 o'clock. So I do ask the interpreters for their assistance. But if the interpretation goes off, then it has to be in English, I'm afraid. So Mr. Timo Wolken for the S&D from Jury, please, for 1 minute.
Thank you very much, and thank you for your presentations today. I would like to address my questions to Mr. Parakkilas. Today, it was revealed that Facebook allows smartphone manufacturers access to user data, and this shows that we might only know the tip of the iceberg of Facebook's data misuse so far. And this is why I'm concerned about the dominant market position of Facebook. The written answers provided by Facebook to the EP show that Facebook considers an exchange of data between Facebook and WhatsApp will be necessary in the future. And in addition, Facebook argues that there are many alternatives like Flickr, Vimeo, or WeChat, a famous European app. Do you think that these services are enough to lead to the assumption that Facebook does not have a dominant market position? And could stricter rules on interoperability for platforms help? Or do you think that Facebook's position is too strong, that this monopoly should be smashed?
Thank you for your questions. I will answer them first, the device part, and then the monopoly power part. So with respect to what happened today, the New York Times ran a story early this morning, European time, uncovering the fact that they, for a number of years, they have been operating partnerships with a number of device manufacturers, including Samsung, Apple, Microsoft, all the major makers of phones and other devices. And as part of those partnerships, they have been offering access to data that was not entirely transparent to users, and also friend data. And in some cases, that data was stored not just on the device, but also on the servers of the partner companies. So this is a fairly significant issue for 2 reasons. In the US, there's a Federal Trade Commission consent decree, which appears to prohibit that kind of behavior. And second, this would appear to contradict Facebook's own testimony to Congress and potentially other testimony and public statements they've made that they ended the friend permission back starting in 2014 and finishing in 2015. So I think this is a very, very important developing story. And I would encourage everyone in this body to follow it closely and to look at how it impacts statements that have been made by Facebook to this body and to your member states. So with respect to monopoly power and Facebook, it's my opinion that Facebook does have an unfair amount of monopoly power, and that the ideal solution would be to separate out the product lines of Facebook, WhatsApp, Instagram, Facebook, into either separate companies or subdivisions that do not share data. And I do not believe, in my opinion, that competitors are able to compete fairly in the marketplace currently. I think what's going on with Snapchat, which is an American company, is a great example of a company that can't compete against Facebook, has had its features copied, and then its user growth has stalled completely because Facebook has such a dominant position. Thank you.
Thank you. For Libe and EPP, Jeroen Lennars, please.
Yes, thank you very much. Actually, I had a question on these device makers as well, but that's answered now. So let me address another question. One thing that was very unclear to me, also as a result of the hearings we had, both in the Congress and here in the European Parliament, is regarding these shadow profiles. Mark Zuckerberg here as well said we need some information on also on non-users in order for our features to work. It's also a security issue for our website. But they're very vague about what kind of information they actually collect. And for me, at least, contact lists or photos, I don't see any way how this would be necessary to keep features of a website or something like that running. Now, they have very much denied creating profiles, but they have agreed that they were collecting some data, and as a non-user, I can actually add that or I can access that data and have it removed. But how does that actually work in practice in your experience, and how is this not creating a profile? Is this something, a claim that you can confirm, or is this something that we should reject?
Thank you for your question. So I have no firsthand experience from my time at Facebook of data collection from non-users. I do believe, however, that Mr. Zuckerberg is correct in that collecting data from non-users is both very valuable from a security standpoint for any company that's operating a large internet service, and also in some cases it is simply the way the internet operates in terms of how a number of standard technologies work. That being said, I think the key area that has not been really delved into is why there is not an ability for a user to either opt out fully of that data collection or at the very least access that data that has been collected and delete it if they so choose. I don't know the answer to why those are not available options for non-users, but I think those are things that should be investigated because I believe that users or non-users should have those same rights as users.
Thank you. For Libe and S&D, Anna Gomez, and I should mention that interpretation is finished for these last two speakers, so it's all in English. Thank you.
Yep. Mr. Parakillas, you mentioned that Facebook business model is at odds with its responsibility in society and that its business model should be broken. So how can we regulators break it? Do you think that with the current technology, targeted advertising should be banned? How could the e-privacy in complement to the GDPR make a difference there? And in view of the new frightening technologies that you just referred, what could we do? And then do you see a link with another way to indeed infiltrate our democracies and actually put them their security at harm? With the links that have been established between Alexander Nix and, for instance, Mr. Chris Cullen of Henley and Partners, dubbed the King of Passports, who organized the sale of passports, the sale of citizenship, global citizenship, namely not just of Caribbean nations, but of European nations.
So unfortunately, I can't speak to the second half of that at all because I'm unfamiliar with most of what you said. But I can speak to the first half. So with respect to targeted advertising, I want to clarify, first of all, the business model you describe is not just Facebook's business model. It is the dominant business model for internet companies. Most internet companies make their money from advertising, and those advertising technologies have gotten much more targeted over time. So there are sort of two broad approaches. One is to target feature-level regulations to ensure that the worst kind of use cases don't happen, and the other is to create different incentives. Again, I would generally advise against being incredibly prescriptive. That being said, I think that there are some very specific and hazardous cases, particularly around elections, where we don't want, for example, voter suppression. I think anyone who raises their hand and says, I believe voter suppression should be allowed, I think that's a very small minority of people. And so what you may need to do is you may need to look at political advertising and create separate rules for political advertising to ensure that the very worst cases don't happen. That will require the tech companies to do a lot of work so they can understand what is actually a political ad and what isn't, because that is one of the biggest technical challenges that they have. So I would encourage you, in the case of elections, to look at that kind of regulation. However, in general, while you could ban targeted advertising, just broadly speaking, I think that would probably be overbroad. And I think I sort of would generally say that there's plenty of targeted advertising that is actually useful, that's helpful to advertisers. And so I would simply say, think about the most dangerous cases, think about how you would regulate for those, and then think broadly about the incentives of the ecosystem.
Thank you. Thomas Jadowski for the EPP.
Thanks, colleagues. Before this hearing, I thought that the film circle was only fiction, but after your presentation, I don't believe that really Thomas Hanks played there something what was really in this scenario. My question is to Professor David Caroll. Sorry that nobody asked you, but you made excellent work, and I am very happy for that, and I am happy that you are here. And my question is, what do you think, theoretically, can somebody influence the European election? And what do you think that you found in your psychological profile? Do you think that somebody can really influence your behavior through the election? Thank you very much.
Just before you answer that, Professor Caroll, I was going to do that dignified thing and ask you the final question. Under Dehont, I had a final question, so just let me add to that, and we'll give you a bit of extra time. Carole Cadwalladr tweeted today, today was the deadline for Cambridge Analytica to turn over the data to you. If it fails to do so, it becomes a matter for criminal proceedings. So my question, if I can add it to the question of Mr. Jadowski, if you could answer this, is what are you going to do when there's nothing from SCL, it becomes a criminal dossier? What's your plan? It's helpful for our committee to know. Thank you.
Thank you for the question. At least I get the good one. So to the first question, and it helps me answer the second one, I'm seeking full disclosure so that I can evaluate your question, so that I can evaluate if my opinions were influenced for the presidential election. I suspect that they were. I suspect that I was exposed to malicious information that was trying to. Now, whether it did is a different question. What am I going to do? Well, I've been waiting to hear from my lawyer, to hear from SCL's response to the Information Commissioner's enforcement order, and we have heard nothing. And so they have not respected the regulator. They have not cooperated with the regulator. They are not respecting the law, in my opinion. And so that's very troubling, because they seem to be trying to use liquidation to evade their responsibility, as far as we can tell. So I expected to help set precedents of data sovereignty in this case, but I did not expect to be trying to also set rules of liquidation as a way to avoid responsibility for potential data crimes. So now that this is seeming to be becoming a criminal matter, we are now in uncharted waters. And I will continue to pursue it because I'm dedicated to the truth, and I continue to have more possibility for the Information Commissioner's Office to pursue their opportunities to redress this, and I will also continue to pursue my claim in the High Court, which is an even broader claim to retain full disclosure, because if I do have the kind of profile that Mr. Wylie describes that I have, then they could know my susceptibilities. to my potential fear or concerns. And so the only way we can know if this works is to see an example dossier of a profile. And the only way we can know if it's accurate is to see the confidence values of those predictions. And if the predictions of my personality are in 80, 90%, then we can understand that their model has the potential to affect a population, even if it's just a tiny slice of the population. Because in the United States, only about 70,000 voters in 3 states decided the election.
Thank you very much, Professor Caroll. So, colleagues, I first want to thank you for your patience for getting through this Dehont list. I think you did it extremely effectively. For colleagues who were not able to ask a question on this occasion, please indicate for the further sessions that we have. And I know who you are, so please indicate, and you will get a slot either from your group or from here, or please indicate to me so that we can do this. And I thank you for your patience and discipline. I particularly want to thank the participants. Before you all go, I think you should understand that everyone giving evidence, the witnesses today, did so through choice. All of them had potential legal issues and other layers of issues. And I do want to thank the Parliament, the Secretariat and the staff, in particular of the Libe Secretariat, who were incredibly charming to all of these people, because they had a choice in what is a very sensitive set of hearings. And I thought it was an exceptional set of answers. I would also indicate that anything that they wished to put in writing where they didn't feel that they could give fuller answers, that's apart from you, Sandy, to seem to have got a lot of the questions. But if you would like to do that, if Mark Zuckerberg can put answers in writing, I don't see why you shouldn't. But seriously, if you want to add anything for the evidence that we gather for the hearings, we would very much welcome it. So if there's anything that you would like to expand on, in your case, Elizabeth, not expand on until the time is right, then we would appreciate it, because for the final set of hearings, I would remind colleagues that there may be a resolution, an oral question from the Parliament. There's a product there is an outcome. So we would appreciate that if you wish to do it. So thank you very much for your presence here today. The next hearing is going to be on the 25th of June, and I can again assure colleagues it will be highly relevant. And the final hearing in July will also include Facebook. Thank you.